Okay, let's get to this final topic now, which is what's happening at the state capitol. Pretty controversial. It's called SB1635, which would make it illegal to warn someone that the police are going to either your neighborhood or even your house or apartment, and they are about to arrest you. Get out of there now, kind of obstructing what the police or in this case ICE might do. What's the legal view on this?
Man, there are legal landmines all over this bill. It's SB 1635, and what this bill does is that it punishes speech alone without conduct. So what the bill says is that you can receive a misdemeanor for warning anybody of police presence, even if the person that you're trying to warn doesn't receive the warning or they don't understand it. And the bill itself is so ambiguous that it's hard to imagine that it could ever be enacted. So whenever there's a bill that punishes speech, there's something called strict scrutiny, where the Supreme Court or a court will have to determine, is there a compelling interest, which there is in this case, which is law enforcement safety. And number two, is it narrowly tailored? That is, is the language in the bill so narrow that it's not going to trample on people's First Amendment rights of freedom of speech? And here, it's not narrowly tailored. They have a lot of ambiguous terms about warning and what that means. It could include whistles. It could include like warning your neighborhood. Generally speaking, that ICE is in the area. It could punish journalists who are in the area. It would punish Paul Revere saying the British are coming. That it would punish that. It would punish Paul Revere. He would be arrested for a misdemeanor on his life.
Poor Paul.
The midnight ride of Paul Revere. Listen, my children, and you shall hear.
One quick question, if you don't mind, Ron, on this. We have somebody in the chat.
Yeah.
Chittamona asked, can they get DNA from hospitals? But I'm guessing in the Nancy Guthrie case, I'm guessing there's a HIPAA situation there.
There is, but they can with a court order if they have probable cause that there is a connection there. But ordinarily, absolutely not. In fact, it's even a controversy that the FBI would do genealogy DNA techniques where they would take, like in the Brian Kohberger case,
right.
They didn't know who he was, and they would input his DNA into Ancestry.com to kind of find out who his family tree is to kind of narrow down the suspects. Even that is frowned upon, but definitely not a hospital without a court order.
Okay.
And then when it comes to the DNA, they say they found non-familial DNA somewhere in that home. But they're not saying what it is. Does that matter? I mean, whether it's blood or, sweat or something else?
There's a lack of information here. I mean, DNA is always circumstantial evidence. It doesn't tell you when it got there or even how it got there. We don't know if it was left there a year ago or 2 weeks ago. So unless we know the circumstances of how that DNA got there, it really doesn't add very much, except for it needs to be chased down. We got to find out whose DNA it was and why it's there. But I wouldn't say that because DNA of somebody else was found there that that's necessarily the killer or kidnapper.
And we can't let you go without saying that you have a pretty popular podcast.
Oh, yeah.
Yes? Okay, what's it called?
It's called No Contest. We just started it about 5 or 6 weeks ago. Just had our last episode pop on Tuesday about the Nancy Guthrie case.
Yeah.
And it's exciting stuff.
Yeah, congratulations.
Thank you.
We love when you come in, Josh. Thank you.
Yeah.
We appreciate it.
I'm going to spend some time listening to that for sure. Hey, by the way, Josh, thanks again. We always learn a lot in 10 to 12 minutes with you. Our poll question as we go